Hey everyone, Harry here to talk about what's up for the week ahead and a little bit of what's already happened this week. What's already happened is Trump has filed a notice of appeal from the Engoron judgment for some 400, 450, 500 million dollars, depending on how you calculate the pretrial interest, but quite a pretty penny. Now, wait a second. Didn't he have to, in order to do that, file a bond to secure it all? And the answer to that is no. This has been a detail not fully understood. He does have to. He's got 30 days from entry of judgment, which was last Friday, to file the bond in order to keep the judgment from being enforced. So 30 days from now, if there's no bond, here comes AG James to take whatever cash he's delivered, or if necessary, go after buildings and the like. She had her slightly snide comment about passing 40 Wall Street every day. So he filed his notice of appeal, which he can do, but what he can't do is keep from being liable for the judgment and giving her, the AG, the power to just basically grab his money and property 30 days from now. So that's why he'll need to post it and why he's already appealed. Okay, and then just so what else is going on? Lots of things being filed and responded to today. You know, we always have the Supreme Court issued its order sheet from last Friday's conference and nothing about immunity on it. But I've already been speculating that it's not happening in conference. If it had, it could have been 10 days ago. Instead, there are papers that circulated, as often will be the case in emergency motions, such as this one. And I think they probably have already voted, and somebody is writing. And without going through the whole Kremlinology of it again, I would say that I think that makes it slightly more likely that they've decided not to grant the stay, and that a dissent is coming from the right, like Thomas and Alito. That's more likely than they've decided to rule for Trump, and because I think that'd be less likely to prompt a separate writing. Anyway, so that's happened today. Also today we have, and for the balance of the week, the continuation of the circus is still in town in Fulton County. Judge McAfee has scheduled an in-camera hearing with the law partner of the prosecutor whom Fani Willis hired, and then at least her account and his account is that after that they began a relationship. His law partner, a guy named Bradley, has been staunchly resisting doing any kind of testimony and has said that he's protected by attorney-client privilege. Of course, it seems as if he sent a email that's got some, saucy stuff in it to the lawyer for Mike Roman, who used to support him as well. This is all now the sort of small community of Fulton County lawyers, and that's what he's scrambling now to protect. We'll see if McAfee lets him do it. As I've said before, I don't see how any of this has anything to do with a potential financial conflict of interest, which would be the only reason to bounce her or otherwise change the trial. Terrible move on her part, and maybe there are ethics issues. Maybe voters will vote her out, but McAfee is considering whether or not to recuse her. That's the motion from defendant Roman, joined by Trump. And I don't see, even if it turns out the relationship started a couple months before, et cetera, I don't see what that has to do with any kind of adverse action toward the case itself. Friday, McAfee, has scheduled the final hearing and argument on this motion. So you'll see each side get up, and then he will be deciding. So that is McAfee and what's happening in Fulton County. Mar-a-Lago, pretty big week. Judge Cannon both has scheduled papers to come in on two different things. One is having to do with discovery that the parties want to either redact or oppose the redaction. More important, though, Jack Smith has until either tomorrow or Wednesday to file his response to Trump's reply to his Smith's motion for reconsideration. And that's less complicated than it sounds. It's an interesting and important juncture because Trump basically sold Cannon a pile of goods, and she agreed with him that the standard for suppressing the names of witnesses in a discovery motion was a very, very high one, and that's just flat out wrong under the 11th Circuit law. So Smith has come in for a motion for reconsideration. Trump, in very Trumpian fashion, rather than saying, okay, our bad, we misled you, came in with just a whole sort of cloud of complex, hard to follow arguments that said you should still do this. I think she really has to back down, or this is the best opportunity that Smith will have had to take her up to the 11th Circuit and move to recuse, because she's done something that just is flat out of line with 11th Circuit law. So Smith will respond to Trump on Tuesday, I think tomorrow. And then on Friday, Cannon has filed a big scheduling conference. That's what it's called, scheduling conference. So in theory, not going through the substance of motions, but she might go through this one. Even the scheduling conference itself, she has set aside a morning and an afternoon session. So there's a lot going on there. This may well be where she pulls the trigger, acknowledging that all the things she has done to date means that the May 20th trial date that's there can never hold, and she may acknowledge that and make that big move. Then, of course, there's so much more going on in Mar-a-Lago, and so much more grist for the delay mill, including the whole back and forth tussle over classified documents, which again really shouldn't matter here very much. It's not, the charge is not based on the content of them, but just the fact of them. But I think Trump is counting on and can count on Cannon to take a long time to figure it out and adjudicate, and maybe even hold in his favor where the law points otherwise. So that's the big stuff. We're waiting. It could be any day for the main event, which is what the Supreme Court will say in the stay motion. And depending on when it does, things go back right away to Chutkan, and we're sort of starting at where we stopped, about 90 days of a delay. Or the court could take it and give it expedited treatment. They'd be deciding it, say, in May, and then and only then would it go back to Chutkan, and that would have real consequences for when this trial, most important of all of them, it seems to me, will take place. Other than that, jury questionnaire in theory, they start to talk about in Mar-a-Lago because the date is still May 20th. Same thing in the New York case, which is March 25th and really will go forward. So there's pretrial motions and the like. So a very full trial and legal docket for Trump this week. But the things to keep our eye on are, one, what McAfee does in Fulton County, both in the hearing today in camera. We won't see it, but we may find out about it. And on Friday in the final arguments. Two, the Mar-a-Lago scheduling conference on Friday and what happens there. And always could be any moment or could be all week or more, the waiting for the Supreme Court decision in Trump's stay motion in the immunity decision from the D.C. Circuit. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.